Our last case of the day is Ginsburg versus ChemMed Corp. Counsel, you may proceed.
Good afternoon. I'm Ivan Matusik. I'm from St. Petersburg. I'd like to reserve 2 minutes of my time for rebuttal. I represent Edward Ginsburg. Mr. Ginsburg was involved in an accepted industrial accident in 1998. He sustained a knee injury, which has now resulted in his undisputed need for total knee replacement surgery. This is the second appeal in this case. Judge Thomas was on the panel in the first appeal, which wasn't argued, but this court reversed the judge's first order as legally erroneous and returned the case to the judge by remand with directions to make additional findings because findings had not been made on the operative facts as this court found them. Each of these appeals has dealt with the somewhat arcane issue of exactly when it is that a workers' compensation carrier provides treatment for purposes of the second statute of limitations in 440.19. There's an initial statute of limitations in 440.19 paren 1 in which everyone has a right to bring a claim within 2 years of the accident, and then there's an extension of the statute of limitations in 440.19 paren 2, which says that if the case is an accepted case and if the claimant is paid compensation benefits or provided medical treatment, then he has an additional year from the last date of payment of compensation or the last day that treatment is provided. So the first appeal involved the judge's finding of when that 1 year period started because this was an accepted claim. And she found that it started, the treatment was provided when the authorized treating orthopedist, Dr. Eaton, prescribed 30 10-milligram OxyContin pills for Mr. Ginsburg. That it started when the prescription was written. And because that was June 2702, and because Mr. Ginsburg did not return to Dr. Eaton until July 2203, it was more than a year, the statute ran. This court reversed on the law. It agreed last May with Mr. Ginsburg that the 1 year period started not when the medication was prescribed, but when Mr. Ginsburg took it. Because of the way the judge had entered the order, of course, she didn't make any findings as to when Mr. Ginsburg took it because it was irrelevant to do so under her ruling, and thus this court remanded the case to the judge for additional proceedings and for findings as to when Mr. Ginsburg took it as prescribed by the doctor. So there were additional proceedings. The judge entered a second order after the proceedings, again finding the statute of limitations to have run, and we think again for erroneous legal grounds. Because by the time of that remand hearing, Mr. Ginsburg had testimony by the way of an affidavit, and by the time of the order, there was testimony by the way of live testimony, unequivocal testimony from Mr. Ginsburg, that he took the medication as prescribed for 30 days from the date of prescription, June 2702. Thus, when he returned to Dr. Eaton on July 2203, he was within his 1 year. However, and even though the parties had stipulated that Mr. Ginsburg had a 30-day supply, and even though there was confirming documentary evidence in the form of an intake sheet from a pain management doctor who saw Ginsburg just 69 days after the prescription, and in which Ginsburg had written on the form very clearly that he took OxyContin for 1 month, And although the doctor had discussed in his report that Ginsburg told him he was out of OxyContin, he was out of oxycodone, all he had left was Zoloft, an antidepressant, and that he had had a trial on OxyContin. Although all of that was already in the record, the judge found, no, Mr. Ginsburg had miswritten the dosage down on that form as 20 milligrams rather than 10 milligrams. Thus, he must have used them twice a day. Thus, he only had a 15-day supply as opposed to the 30-day supply the parties had stipulated to. And that 15-day supply ran out on July 11, 2002. Thus, when he returned to Dr. Eaton on July 22, 2003, it was more than a year. The statute ran. That was the second order. That's what we've appealed. But before we appealed, we filed a motion for rehearing, and we pointed out to the judge that it didn't make any difference. We thought the judge was wrong on the finding of a 15-day supply, on the finding that it ran out on, that the statute ran on July 11, but we pointed out that it didn't make any difference because Ginsburg had returned to the carrier on July 10, the day before the statute would have run, and said, give me a doctor. I'd like to go back to Dr. Eaton, and the carrier mistakenly said, sorry, the statute's run, go away. It was only after that that Mr. Ginsburg actually went on his own 11 days later and paid for it himself. The judge did not address the rehearing point at all in the order.
By raising the issue in a motion for rehearing after one appeal, have you adequately raised this issue of the contact with the adjuster?
Absolutely. Absolutely, because...
For preservation purposes.
Absolutely. Well, yes, because it was raised in the initial stages of the proceedings. If you look at my reply brief, you'll see where I quoted the trial summary, which was given to the judge, trial summary, the response to the employee carrier's motion for summary judgment, summary final order, which had been filed before the first order. And it was talking about whether, the argument in the summary proceedings, which was the memorandum, which was filed September 1404, before we even had the 30-day stipulation, was that Ms. Ginsburg returned to Dr. Eaton at his own expense July 2203, after having requested and being refused authorization by the carrier on July 9, 2003, and July 10, 2003, respectively. 1 year from the day the 30-day supply of medication would run out is July 2603. 1 year from the date a 15-day supply would have run out is July 11, 2003. Thus, Mr. Ginsburg had either requested and been refused authorization to return to Dr. Eaton, or in fact had returned to Dr. Eaton at his own expense within 1 year of the date he was last furnished remedial treatment in the form of prescription medication provided by an authorized physician, which is precisely the argument we made at the motion for rehearing, precisely the point we're making here. And it was raised. It fell by the wayside. And why did it fall by the wayside? Because after this was raised, and part of what was raised here was, wait a minute, this is a summary proceeding. We have a factual issue. The adjuster testified this was a 15-day supply. Ginsburg says it was a 30-day supply. Ginsburg says he took it over 30 days. He pled it. We have a factual dispute. The carrier wanted to go forward with the summary proceeding. To do that, there had to be no longer any issue of material fact. So they stipulated the 30 days. So after that, who cares if it was 15 days? Until the judge interpreted the very plainly written 1 month on the intake form to actually mean 15 days. So it was raised. And of course, that point really makes all of the competent substantial evidence points in this case, and there are many, and they're a little unusual. And the judge's finding, turning 1 month into 15 days in the face of a stipulation that it was 30 days is sort of unusual. But that really doesn't mean very much because it doesn't make any difference. If it was 30 days, then it was told, as this court said in its opinion in Ginsburg 1, it was told when he went back to the doctor on his own. It was told even though the carrier didn't pay for it. It was told even though the carrier still hasn't paid for it, even though the carrier refused to pay for it. And the reason it was told was because the carrier had a present duty to provide that treatment when he went back, and they didn't execute it. And therefore, under the two existing cases, both of which are Mr. McCabe's cases, the Steins case and the Turner case, and the only cases that even remotely touch on this point, it's a waiver. The statute of limitations can't be legally raised. That's what would have happened as of July 22, 2003. Same thing would have happened as of July 11, because in both Steins and Turner, the claimant had not gone back to the doctor on his own. It was the event of the claimant requesting the carrier to execute their known and existing duty to provide medical, which in fact was considered to be the provision of medical treatment in fact, and which in fact...
Counsel, you have used your entire 10 minutes plus a little. I'll give you about 30 seconds for rebuttal.
Okay, thank you, Your Honor.
Okay.
May it please the Court. My name is Robert Alston, and I represent ChemMed, DBA, Roto-Rooter, and Gallagher Bassett Services. In direct response to Judge Van Nortwick's question regarding the waiver of this issue, I would disagree that this has been preserved for this panel. Specifically, a claimant says that it was made a part of his original trial summary. Well, that is true. That trial summary was delivered to the JCC at the same time as an order or a motion to continue the original merits hearing on this case. Subsequent to that, there was a motion filed for summary order, and in response to that summary order, or motion for summary order, the claimant did provide a opposition memorandum, which does not mention at all the alleged waiver argument or the argument that they asked for this treatment in July 10th, 2003. If we continue to look throughout the rest of the proceedings before the JCC in this court, that issue was never raised again, either at the actual hearing that occurred in the first time for the summary order. It was not raised in the appellant's motion for rehearing at that time. It was not raised before this court when this court reviewed the order from the JCC and determined it to be remanded back, and was not raised at the remand hearing. In fact, the first time that we see it, other than in a summary trial order, which was never used by the judge, and only becomes a part of this record when it was attached to the appellant's reply brief, the only time we see it again is after the judge makes the ruling that the claimant was not an accurate historian and therefore did not take the medication as prescribed and that the statute ran. Consequently, that issue was waived. Now, claimant has made an argument that because the facts that the adjuster was contacted, that's enough to also, in some of his briefs, to maintain that action. However, as this court recently found in Wilcox versus Agrimart, the fact that there are specific instances or even facts developed at a hearing that could help purport or to advance an argument is not in and of itself enough to preserve that issue for appeal. Specifically in that case, there were some facts developed as far as a coming and going defense, and yet there was never any argument on it. There's never been any argument except at the after the remand hearing, this latest time, and in that trial brief the first time. Consequently, that case and that argument is waived. The important issue here revolves around the procedure of this case and how it sits before this court today. This court in Ginsburg 1 made a precise finding of law. And that precise finding, and this court said, on the specific facts of this case, we agree with the claimant that the statute of limitations does not run until the 30th day, so long as the claimant took the prescription as prescribed. As the facts and the law of this case, as this court found in Warwick versus a Lighthouse Restaurant, that finding controls all subsequent proceedings. This court also in the remand made specific instructions to the JCC. Specifically, the JCC was to make a factual determination as to when the claimant last took the medication as prescribed during that 30-day period. Again, such a specific instructions on remand requires that the JCC stays within those boundaries. And in fact, this course in Elias versus Anderson and Shaw Roofing, which Mr. Matuzik firm was a part of, this court specifically stated that JCC was not at liberty to go outside or to make findings other than specifically what this court asked for that judge to do. Immediately upon receipt of this court's opinion in Ginsburg 1, the claimant filed an affidavit stating, swearing under oath, that he had taken 1 pill per day for 30 days from June 27, 2002. The JCC held an evidentiary hearing, and at that evidentiary hearing took testimony not only as the affidavit, but also took testimony as far as direct testimony from the claimant, had the opportunity to observe the claimant, the candor and the overall proceedings, and also was presented with this intake sheet that supposedly purports to be evidence of the highest nature that the claimant took the prescription as prescribed. And specifically, the record at page 9, when the claimant was asked under direct as to when he took the medications, on page 9 of the record, starting at 18, he's asked by Mr. Matuzik, did you receive a bottle with 30 OxyContin in it? Answer, yes. What's your understanding as to how you are to take it? Take 1 a day for 30 days. And did you? Yes. Going on to page 10, are you sure of that? Absolutely. Well, that absolute certitude changed by the time we get over about 8 pages later when he's asked on cross-examination about that affidavit and about when he took the pills. Line 23 of page 18. You said he prescribed OxyContin for you when you saw him in 2002. Is that correct? Answer, 2003. Question, okay. On June 27, 2002, in your affidavit you said, and you just testified, that he prescribed OxyContin to you. So is it 2003 or is it 2002? Answer, the last visit I seen him, I think it was either 2002 or 2003. I don't remember the last exact one. As we continue to look at the rest of the record, I won't go through it for brevity's purposes, there's numerous instances where not only did his testimony conflict from direct and cross, but conflicted with the affidavit. And in fact, the JCC listed in her order numerous findings where his testimony not only conflicted with itself, but conflicted with the record evidence. As such, as on remand, and as her duty as trier of fact, as this court has also held in Urban versus City of Daytona Beach, it is within the JCC's purview to believe or disbelieve some, all of the testimony of a witness, even uncontradicted testimony. Here, we see that there was numerous times where his testimony conflicted. And in fact, as Judge Thomas indicated in his concurring opinion, this is a problem with the case. The case of having to ask a witness to remember an event at least some 4 years in the past, as to specifically whether or not he took pills, is problematic. Unfortunately, that is the law of the case, and is what we have to deal with. Throughout this case, the claimant has asserted that through his testimony or through his affidavit that he is sure and positive of when he took the medications, yet it shows otherwise. And in fact, as the claimant testified to or talked about this intake sheet from Dr. Hanna, which supposedly shows beyond the shadow of a doubt that he took it as he says he did, if we look at the intake sheet, we see that he lists under current medications, and this intake sheet was filled out 69 days after he saw Dr. Eden. He testifies and puts on here under current medications, OxyContin 20 milligrams 1 month. When asked about what that 1 month meant, he indicated that, well, it means he got a month's supply from Dr. Eaton back June 27th. The JCC did not find that his testimony regarding that equated to, I took 1 pill per day for 30 days. And in addition, he did not mention oxycodone, which the records which were in before the judge, JCC, the CVS records, indicated that if he had been taking those as it appeared that he should have been, that would have been a current medication. He also lists hydrocodone, which there's no information in the record that shows he was taking them at the time he filled this out. Consequently, the JCC, when she indicated in one of her findings that if we were to believe the claimant based on this particular sheet alone, he would have taken it over 15 days. And I would take issue to the fact that she made a finding that it was a 15-day supply. The evidence and the stipulation in this case is no doubt that he received a 30-day supply, which was 30 pills. And in fact, if that was not the case, then this case never would have been remanded. If this court believed that somehow the stipulation, which is clearly stated in the record, that he received a 30-day supply, which meant 30 days, that he took them for 30 days, if this court believed that to be true, he never would have been remanded back to the JCC to make specific findings. Obviously, that evidence wasn't there. It just means there was 30 pills, not that he took 1 per day for 30 days. And in fact, when this was brought up at the rehearing, and Mr. Matuzik brought that to the JCC's attention, you can even see where she's kind of confused. Well, I made that finding. Instead, if you look at the totality of the evidence as she did, you can see that it's not that finding. It's just one more conflict of many in the claimant's evidence, in the claimant's testimony. This case is here under the competent substantial evidence review. And as this court's seminal case in Swanigan versus Dobbs House, it is not this court's duty to review the evidence and to see if there is competent substantial evidence to find a hearing that's opposite to what the JCC found. And instead, as this court further delineated in Ullman versus the City of Tampa, it is this court's to review the evidence and to find that if any evidence and its permissible inferences supports the JCC's finding. Here, the JCC lists numerous times where not only does the claimant's testimony conflict with himself, but it conflicts with other evidence. Therefore, she did not find that he took the medication as prescribed, which was the law of this case, and therefore the statute ran. Consequently, we would respectfully request that this court uphold the JCC's finding that there is competent substantial evidence that the statute of limitation ran, and that all claims should be barred. Thank you, Your Honors.
Thank you. 30 seconds. I'll read what I read to the judge that she didn't believe. The order says, this is page 886 of the record, I find that the evidence substantiates that the claimant filled out an intake sheet for Dr. Hanna in September 2002 showing that he was taking OxyContin at the rate of 20 milligrams per day. This would require the claimant to take 2 pills per day, and he would have had only a 15-day supply, which would have exhausted the prescription by July 11, 2002. I find the statute of limitations did expire prior to the claimant filing the petition for benefits. That's precisely what she found. She found it was a 15-day supply. We have another legal point, and the legal point is that the carrier actually stipulated not only that it was a 30-day supply, but they effectively stipulated that it was taken over 30 days, because Mr. Ginsburg pled both. They accepted his pleadings in their stipulation. They convinced the judge that we should go forward saying there were no material issues of fact. They didn't say, oh yeah, a material issue of fact, whether he took it as prescribed for 30 days still exists, because if they had, we never would have had the first order. We wouldn't have had any summary judgment proceedings. We'd be trying that issue. They stipulated to it. That's why it fell to the Wade side, because there was no reason to talk about 15 days anymore after their stipulation. There no longer was an issue. As a matter of law, they stipulated he took it. Thank you.